Welcome to day 2 of the 2024 Annual Conference on Social Enterprise and Impact Investing. We had an amazing and energizing day 1 yesterday. On behalf of my co-chairs, Leslie Cornell, Ruth Gao, again, just want to welcome you back. I also want to quickly and repetitively thank the Grunin team, Svea Schönberg. You guys probably all said hi to Stephanie Schwartz on your way in, Yuna Kim, and the many others at the Grunin Center who have made all of this work for us. I also want to once again thank the program committee, all of the theme leaders, panel leads, panelists, all of the people who've contributed to the substance of this meeting, because it is a rather heavy lift for everyone involved, and it is the secret sauce of this conference. We, as practitioners, are pulling together the things that we're excited about, want to talk to our colleagues about, share information about, and it really does make this a special and unique conference. So thank you all. One thing I did want to call out again is the innovation team and how all of the interesting things that they have added to the conference schedule. I think many of you just came from the structured networking. We had a Hall of Impact. We have theme groups later today, which I hope you join. This is all new and interesting, and I think has added to the connective tissue that we're building at the conference. One last thing that I'll just say in my welcome is you heard Mary Rose yesterday mention a little bit of the origin stories of this conference, and one piece of that was around 12 years ago, Deborah and I were at an Andy annual conference, and this was, I don't know if many of you remember, they used to have them at the Glen Cove Mansion out in Long Island, and we were sitting there having dinner, talking about issues that we were facing and saying, wouldn't it be nice if? And the if is this. And so I just want to say it's been so wonderful and over the last decade to play a small role in how this has all come together. And again, to see this connective tissue form. And one of the very, I guess, just concrete ways that I have seen this play out is we now are at a place where organizations operating in impact, legal teams are poaching from other legal teams. And it's a funny example, but 10 years ago, we may have had one in-house lawyer at each shop if you had a lawyer. And now we have full teams that are forming. And it really is a wonderful time, I think, to be in the space. And there's a lot of, energized and skilled people who are doing the work. So that is all of you. And thank you for being here and contributing to that. And with that, I'll pass it over to Svea.
Thank you so much, Kevin. It's been so much fun getting to know you over the last 24 hours. And I know there's still a bunch of people I haven't yet talked to. Please find me. I'm trying to find you, but hopefully we'll meet. And please, in a related matter, we have a survey to fill out. I really want to know what's been working well for you. What do you want to see differently? How do you want to get engaged and involved for next year? It doesn't have to be a heavy lift, but what do you see yourself doing next year as part of this conference? And talk to me about it if you have any thoughts. And as Kevin mentioned, so many people put in so much work. So again, if you weren't here yesterday, I want to thank the co-chairs, Leslie, Kevin, and Ruth. I want to thank the innovation team. They've been amazing. The planning committee, which is more than 20 people, and that could be you next year. And also our speakers. Again, over 100 people are speaking at this conference. And just for the snapshot, 390 people registered for the conference. 110 of them are speakers, so a huge percentage of the total, and 48 come from outside of the US across 6 continents. So it's a pretty diverse crowd. We have dozens of students, so please talk to them. They're kind of the next generation who's going to carry on this work, so we want you to get to know each other. Today, in addition to panels and table talks and workshops, we also have one more networking opportunity, and it's going to be at 1:30. And the vision for this session is that it's theme-based. So if you've been following a particular theme throughout the 2 days, you can meet with others who've been going to the same session and kind of reflect on what you've learned over the last 2 days, make some new connections, and talk out what you've learned. So that's at 1:30 upstairs in Golding. Also later today, we have a fun closing plenary, so don't leave early, please. It's at 3:45. It'll really be fun. The former general counsel of Ben & Jerry's, as well as a young social entrepreneur, are coming to speak. And we're ending with ice cream and cookies. And so you can take home cookies with you, bring them to your family. And so that'll just be a fun way to say goodbye. And you can hang out in Greenberg and just say your goodbyes with all of your new and old friends from this experience. And once again, we have only 15-minute breaks that we're sometimes going to override to give more time to the sessions. And this is an example of one. We have a break after this plenary that we're just going to breeze through and give the panelists 10 more minutes. So this is going to end at 10:55, and then you'll go straight up to the second floor. You can pick up a coffee, you can pick up a bagel, you can eat anywhere but not here. So get what you need, take it to your next session. And also wanted to say something for those who don't stay till the end. Save the date for next year, June 3rd and 4th, 2025. We're going to do this again. We'll send all of this out in the post-conference email, so you don't need to write this down. But next, I would like to hand this to Mary Rose, our Sustained Commitment recipient, who's going to introduce the panel.
Good morning, everybody. So today we're going to enjoy a really interesting exploration into a research project led by Dana Brakeman-Reiser into social enterprise law around the world. And we'll learn of a lot of things, including the tension between building social trust and promoting scale. So this is an interesting experiment into how innovation has been implemented around the world and how is it working from a very cross-cultural perspective. Dana Brakeman-Reiser holds a chair as Centennial Professor of Law at Brooklyn Law School, where she teaches for-profit and nonprofit corporate law. She also served as Vice Dean. She's a globally recognized expert in the law at the intersection of business and charity. Her work on the law of social enterprises, firms that pursue profits for owners and social good, define the field. She has also written extensively on law and finance for philanthropic organizations and sustainable investing. Her panel is really esteemed. We have one panelist who's joining us from afar, so that's something that we're working on the technology for. So. Yes, he's here. Good. See, that's one of the problems. We can't see him, but he can see us, so be careful. Geertra Leideke-Huber, whose name I've now mispronounced, is an assistant professor of tax law at the University of St. Gallen and a vice director of the Institute for Law and Economics there. Her research focus is tax law with a particular focus on the questions of sustainability and philanthropy. She received her PhD in tax law from the University of Geneva and her BA as well, and an advanced MA. She also has an MA of European Public Affairs at the University of Maastricht and a BA of Law from Vilnius University, and she's been a visiting scholar at MIT and other institutions around the world. I wouldn't normally go into the details, but I just want you to know how distinguished this group is, really. Alvaro Pereira, who's on the screen, is an assistant professor of law at Georgia State University College of Law. His research focuses on the evolution of corporate law, in particular how changes in legal rules and practices shape the development of startup and venture capital ecosystems and the construction of sustainable economies. He, before joining the College of Law, was a lecturer at the University of Leeds. He was the Max Weber postdoctoral fellow at the European University Institute in Italy and an academic visitor at the University of Oxford. And he's been an adjunct lecturer at many universities across the Americas. Meunier is the editorial manager at the International School of Public Administration and a PhD candidate in public policy at Georgia State University. Her research interests lie in nonprofit commercialization, cross-sector collaboration, and social enterprises. She worked formerly as the deputy director of the Center for Charity Law of China Philanthropy Research Institute. She consulted national policymakers in the legislative process of China's first charity law and helped draft local policies on nonprofits and social innovation in Beijing, Shenzhen, and Yunnan. So we have a really wonderful, diverse group and a wonderful leader, and welcome.
Thank you, Mary Rose, and thank you to everyone. So I am going to ask my panelists when they speak up to each tell you their name so that I don't also mispronounce everyone's name, and I can model that. I'm Dana Brackman Reeser. You can remember how it sounds because Reeser sounds like research, and that's what I do. This is a huge project, as you can see by this doorstopper of a book that we produced as the initial product of the research. It was commissioned by the International Academy of Comparative Law, which is an organization out of Paris that is many decades old. And every 4 years, they hold a conference somewhere around the world, and they select about a dozen topics that they would like to produce research work on and ask for someone to lead that research undertaking, including managing a group of esteemed reporters who will report on that topic from their jurisdictions around the world. And I was honored, together with my colleague Stephen Dean, to be selected to be one of those reporters to manage that process. And they selected the topic of social enterprise law. And they were interested to understand how jurisdictions across the world are responding to the desire to accommodate ventures that use business methods to achieve social goals. And that happens in an unbelievable variety of ways in different jurisdictions around the world. We were so fortunate to have 27 jurisdictions on 6 continents. No one gets Antarctica in, right? To participate in this research and in this book, which, if you're affiliated with a library, I encourage you to ask your librarian to acquire. It's a little hefty for a personal collection, more of a reference volume, but it includes reports from those 27 nations that we are going to try to give you some taste of, but obviously you will certainly get more of that richness if you look at the whole thing. The first 75 pages or so is a report that was co-authored by myself and Professor Dean, trying to draw out some key insights from this work. And I also wrote an article recently for the spring issue of the Stanford Social Innovation Review that is a condensed version of those insights, trying to draw out, what can we learn from this vast comparative project? And that's also our topic here. So just to flag for you some of those key points, we really noticed the impact of baselines, right? And this is probably very basic for anyone who does comparative law work, but this was my first really significant comparative project to realize that you can't understand what kind of innovation is happening in a jurisdiction until you understand what the baseline that their law operates from and how different those are across the world. So that's very much a topic that is addressed in this volume. We also picked up in these various jurisdictions diversity of opinions about how law might encourage those ventures that blend a social mission and profit making, and particularly a lot of use of different kinds of social enterprise identifiers, legal forms, but also a lot of use of certifications, special certifications, often by public organizations, but sometimes by private ones as well. And the idea that those are legal interventions to try to aid social enterprise development was a key insight from the volume. And as we looked at those many and varied interventions, we noticed that they fell along a spectrum from those that seem to focus more heavily on encouraging trust in the entities that they identify as social enterprises, particularly by taking the fairly intense step of applying some kind of limited distribution constraint, like a dividend cap or a partial reinvestment mandate. And in the SSIR article, I profile Belgium's approach to this. It's a certification. It includes a dividend cap in order to be certified as a social enterprise. On the other end of the spectrum are approaches that are much more familiar to those of us who work in the US space that don't include any kind of distribution constraint, try to use other methods to identify social enterprises as the kind of trustworthy, mission-enhancing entities, but do reject the idea of a distribution constraint because they're interested in promoting scale, particularly promoting scale through openness for private capital to invest in the space. And so we also saw kind of on the other side of the spectrum, many of these identifiers, whether they're certifications or organizational forms, moving in that direction and trying to engage that private capital. Sometimes the ones with the distribution constraints are paired with the opportunity to draw in public capital from the government. So that's an interesting additional note that I would mention. So I'm going to now turn to engaging with some of our panelists to have them draw out some of these examples for you and tell you a little bit more about the experience in their jurisdiction. And let's jump right in with Alvaro. So Colombia, like the US, has opted to design legal structures to encourage social enterprise without additional distribution constraints, right? So no dividend caps, no reinvestment mandates. And it has also evolved over time. And Alvaro has some exciting things to report, even since the publication of this volume, which came out just at the very, very end of December in 2023. So Alvaro?
Thank you very much, Dana. Just want to make sure, can you hear me well?
Yes.
Yes. Okay. Thank you all. Thank you very much. And my apologies that I couldn't attend in person, but I'm trying to follow the event from the distance. I'm currently in Latin America conducting fieldwork precisely to expand a little bit of what we started over there. As Dana mentioned, my report focused on Colombia, and I wanted to highlight two things related to the baseline that Dana referred before. Latin America, in terms of social entrepreneurship, has two characteristics that I find quite interesting for all of us. The first one is that there are enormous growth opportunities. It has underdeveloped markets. So from a business side, there are unrealized markets that offer opportunities for investors. But it is also a region with unrealized social objectives: access to finance, education, employment, training, sustainability. So all of these to highlight that there is it's a special context to promote social entrepreneurship. Traditionally, the two aspects that we've been focusing on, scale and trust, have not really been promoted by governments. So the traditional business entities were not really available for most entrepreneurs. In the region, to give you a sense, those of you who have worked over there, most entrepreneurship is still informal. So there are not many opportunities for scaling up, even for companies that are exclusively for profit. And in terms of trust, distribution constraints are only available for nonprofit entities. There is a survey conducted by a nonprofit organization with businesses that self-identify as social enterprises, and most of them adopted a for-profit entity, but reported that they felt that it didn't provide the conditions to access capital or provide the trust that is needed. With that context in mind, I wanted to highlight that there are growth opportunities and unmet social objectives. The government in 2018, inspired by the work of BLAP in the United States, proposed a reform that was later introduced by law. Initially, the reform aimed at creating a new corporate entity that offered some advantages for social entrepreneurs, such as distribution constraints and some additional legal benefits for mission-driven businesses. However, when the bill was passed by Congress, it changed, and it ended up being a legal certification system. So as it was passed by Congress, it is a legal certification available to all business entities that commit to do three basic things. The first one is that they must include in their charter and bylaws an interest clause with 5 specific activities committing to specify adopting a specific business model, corporate governance structures, labor practices, environmental practices, and social practices. These ones are defined by law, and businesses must indicate specifically in those 5 areas how are they aiming to advance public goals. The second main requirement is that directors must consider, and this should be also included in the bylaws, a mission or a collective benefit, as the law refers to. And lastly, disclosure rules. So the companies must disclose in an annual report following one out of 5 international standards. One of those is the standard that you may be familiar with, provided by B-Lab, but another one by ISO. And that report must be available online and in the headquarters for any stakeholder to consult. So in the report, I argue that these 3 main innovations are aimed at increasing trust. So trust from investors who may be willing to support mission-driven businesses. In terms of scale, what are some of the benefits that some of additional innovations that the law introduced? As Dana mentioned before, this legal certification does not entail distribution constraints. So ideally, businesses that are committed to support this public mission will be able to access capital from various sources, as they wouldn't be constrained by legal limitations, as nonprofits are generally constrained. But other than that, there are not many other benefits. So the incentives that the law created are generally available to other small and medium enterprises. One that maybe I would like to highlight, and we can discuss further with the panel, is that the law provided that if there is a public procurement process and one of these entities that adopted the legal certification is tied with a different entity, then this legal certified company would operate as a tiebreaker. So it would get the contract ultimately. But that is a minor incentive for companies. So overall, the momentum that was created with the legislation has been diluted over time. The highest numbers that were registered, new companies adopting the legal certification, it peaked in 2022. And from then on, we have not seen that many companies adopting the legal certification. I'd like to refer to some of that later on when I present some of the results. But for the moment, I would say that there has been lack of consistent support by the government offering additional incentives, which has led to many mission-driven entrepreneurs adopting traditional entities, even if those don't provide benefits in terms of scale or trust.
Thank you. So appreciate you making time for us during your research trip. So I'm going to turn now to Giedra, who served both as the co-author of our report on Switzerland, but also a co-editor on this monster book, including tremendously helpful work dealing with any reports that were written in French, because the Parisian International Academy of Comparative Law welcomes reports in English or French, which I was not equipped to edit in any way. As I mentioned, in Belgium, many European countries have built legal structures, whether they are specialized forms or certifications, that incorporate these limited constraints on profit or asset distribution. But there's a tremendous diversity as well, including a very different approach in Switzerland. So, Giedra, can you share with us a little bit about the variation you see, particularly in Europe?
Yes, thank you very much. With pleasure. Dana is very generous. There was only one French report, which I helped with.
But when you volunteered, it was Annie that came in French.
Yes, we did not know. So yes, and I was very happy to take part in this project. It was very interesting. And I also written a national report with one of my previous colleagues, Ksenia Karametaxas. So actually she wrote the major part of this report, and I did the tax part, which is important but not very big. Now currently she's on maternity leave, so doing some important work at home and in Switzerland. So where to start with Switzerland? I heard once a saying like, do you know how every Swiss joke starts? So it's looking over your shoulder. So it describes quite well, very careful, very neutral approach. We want to respect all the parties. We don't want to create problems. Very careful approach in adopting some policies which neighboring countries have already adopted, maybe worldwide. This could be good, this could be bad. One of the bad examples, not related to this conference, but I don't know if you know in which year the last canton in Switzerland gave a right to vote to women. Any guesses? I almost don't dare to say this to you. It was 1991, the last canton. Yes, and it was not voluntarily. It was by Supreme Court decision. So very, very conservative on some points. But on other fields, like now we are going back to social enterprises, it really does not over-regulate too much. So leaves a lot of flexibility and a room for individual initiative, local improvements. And the key takeaway about Switzerland is that there are no specific regulations in this field. So the general corporate law framework applies, and also tax law regulations, which are all are applicable to corporations and to charities. So depending in which field you fall, you can be either considered as business company or a charity as a social enterprise. Social enterprises are not defined by law, but we use this term in administrative documents, so published by the federal government, and they are described as private businesses that do not focus only on, profit making, but also on some social, cultural things, well-being of the society in general. And because there is no defined model, so the Swiss context is really characterized by a variety of social enterprise models. So we can have limited companies, but we can have traditional, foundations, associations, and other type of companies that, in fact, do social enterprise work. It seems to be that the current legal framework is quite conducive for social entrepreneurship. So we see this from statistics because there is, we have those measurements for social entrepreneurship. It's called Barometer of Social Entrepreneurship in Switzerland. So it's an association which is called SENS, Switzerland, and it's been established for a lot of years already. And even federal government cites the statistics. So they say that we really see social entrepreneurship in many economic sectors. It tackles a wide range of societal objectives and is present in all legal forms. So Switzerland, the approach is less is more. Less regulation is more, right? There were demands, and one was very recent, to create specific certification. I will just mention briefly what do we have in other, for instance, European countries. So those demands come every 4 years, and they are being rejected by the federal government, always on similar arguments. That basically the company law framework already allows all type of social entrepreneurship activity. We don't want to create different rules for different types of companies for the question of equality and issues of competition, basically. And as we have already a lot of different legal forms that do social enterprise work, now creating a certification might create really problems in implementation and delimitation between all those business models. And in the last rejection, which was published 3 months ago, they said that overall such a change would create more bureaucracy, perhaps preferential treatment, and therefore injustice for some companies. So, yeah. This last suggestion to create a certification or just some legal basis for social enterprises. Also suggested in a very vague way that tax incentives could be used. So as a tax lawyer, I don't know if I made it very clearly, I'm not corporate lawyer, I'm tax lawyer, so I really do tax issues. As a tax lawyer, I'm always very careful introducing corporate tax incentives, for in any field. Corporate taxation is a very complicated field, and some small things can have ripple effects, which we have not even discussed. And if things are working without, I would also advise not to, not throw tax things into it and create additional tax planning opportunities for maybe companies that actually not, doing social entrepreneurship. So that would be my position on that. And yes, that was about Switzerland. Now, European jurisdictions, some of them, as Dana already mentioned, developed certifications, and a few of them even legal forms for social enterprises. So it's not worse or better than Switzerland. It's very, very jurisdiction related, right? Switzerland is a federal state with 26 cantons who have a lot of legislative prerogatives. So it's difficult to compare, for instance, to Italy. But in Italy, for instance, there are legal forms of social cooperative and social enterprise. So for now, they don't have tax incentives. But as our reporter said, there might be tax incentives coming in the near future. So also everything which relates to tax, we don't have a lot of time to evaluate whether it's really efficient, because social enterprises are so new. It's all a bit experimental. In France, they have a certification. They have the status of entreprise de l'économie sociale et solidaire, entreprise à mission. So it would be two status that you can get through certification process. So you incorporate as normal corporation, and then you apply for registration. Our reporter said that especially social economic companies are not very popular. Unfortunately, there is something which is missing. Not many of them have registered because there is not many advantages in that, apparently. And a little bit the same situation, if we can compare anything, is in Denmark. They also have a register where companies which found themselves that they are social, enterprises could register, but this number is really, really small. How is my timing? It's good. Yeah. Okay. So for instance, in Denmark, you would need, if you want to register for this register, you must change your articles of association to specify that one of the purposes of the company is to have significant positive impact on society and the environment. And there are some specific duties for management and all that. So that was about legal certifications. And in many countries, we could have private certifications like B Corp. We have this in Switzerland, and some, for instance, even law firms apply. There are very little law firms. And I discussed with one of my friends who is a partner in one of few Swiss French law firms who received the certification. And he said it's really hard actually to get all those points, to reach the level. And he said in Switzerland, we receive a lot of points just because we are in the jurisdiction that basically has basic legal framework for protecting, The questions are like, do you pay all your employees? Like, do you have people working in the black market, So you don't have that. So you already get points for doing that, so yeah, but we can have this as well. That was my overview. Thank you, Dana.
Thank you so much. So I want to turn now and hear from Meng, who wrote a fabulous report for us on developments in China. And as she'll describe, there are competing certifications operating there, and they've been developed on the local level, which is a really interesting difference from a lot of the other jurisdictions we covered, and they've been evolving kind of in real time. So maybe you can share a little bit about your report.
Yeah, thank you, Dana. And before I start the case of China, I want to say the project is really amazing because all these jurisdictions, Dana and the article editors design comprehensive surveys. So if you need reference for these countries on for-profit legal system, non-profit legal system, and hybrid legal system, it's all there. So the concept of social enterprise in China is quite popular now, but it's only been around a little more than 10 years. It came into being thanks to international intermediary organizations like the British Council, who we adopted from the Western world on the social and the for-profit hybrid organization. And there was also momentum from both the for-profit world and non-profit world to converge on this spectrum between profit and non-profit. Because after decades of singular focus on fast economic growth, the for-profit world realized there's a need to balance social value with just investment returns. And the non-profit world, there was the first generation was fostered by international funders, but that being declined. And in China, it's really hard to get the permit to public fundraising, and with the economic growth slow down, they are trying to figure out ways to get some earned income and to be sustainable. Our legal system is a statutory one, similar to civil law countries. We don't have case law. No, we have National Congress is the highest level, that the Constitution and the National Congress passed laws are the highest level, but we also have local regulations, and the central government can have their governmental released regulations. And currently, there is no legal definition of social enterprise in China, because we just had the charity law in 2016. So nonprofits is still a new term to most of the general public. Even judges, lawyers, work on cases of donation disputes based on contract law. So they say if a charity does not deliver, you can just revoke the donation because it's a breach of contract. It's just still new and evolving in China, both the nonprofit sector and the hybrid sector. So our for-profit and non-profit legal forms are separate from each other. It's so companies can only be for-profit. If you want to do a non-profit, you register with the Civil Affairs Bureau, and they have standalone legal forms for you. Foundations, associations, and social service organizations, just roughly the operating ones. So at the national level, the current legal system that do not accommodate the hybrid nature of social enterprise very well. So since 2015, there are 4 local accreditation certification system have been rolling out in different areas in China. The first one was in Shunde. It's one very rich, dynamic, heavy business culture city in the Guangdong province, East Coastal area. It's home to a bunch of Global 500 companies. So they, because they're kind of a special economic zone nature. They have local legislative power. They have a special piece of local law to establish a chartered agency to work on. It's called a Social Innovation Center, and their major job is certify the social enterprise, but locally. And it is so this is the model of a chartered organization. They have been certifying dozens of organizations because it's local. And the second one is just right after Shunde. It's called the Shenzhen model. So it's housed in China Charity Fair. So it's a big convening of nonprofit practitioner at each year. And during the session, they certify nonprofit and for-profit for if they are a social enterprise. And this organization is GONGO, so the Civil Affairs Bureau, the regulator of nonprofits, established this organization as a nonprofit. And the third one is Beijing, is similar. They established association of nonprofits, and also they are backed by the government, but their nature is nonprofit. They certify both for-profit and non-profit. And the fourth one is very interesting, is in Chengdu, the home to Panda, that city. So they have a lot of local innovations based on community. The local government agency, the company regulator, have this. It's pure like public certification. And if you register and you prove your social function, you can have social enterprise in your legal registered name. And the interesting evolving of these certification systems over time is that the 2015 versions, when they first started, is quite similar to those rules and standards of SE UK, those early pioneers in the field. We have specific distribution cap, asset log, and if you're a nonprofit, you need to have a minimum percentage of your income from business trading, not from donations and grants. But over time, those clear thresholds has been repealed, just to be more inclusive, because we found that the practitioners, it's just a little bit hard for them to, because the concept is new and whereas people come from different corner of the society. Some know the business rule better, some know nonprofit better. So, but still, the one that is consistent is a primacy of social goal. And then the current 4 versions have the expectation of like asset log and the distribution cap, but there's no clear threshold. So the experts just judge case by case. If you have these rules in place, you add points in your evaluation. Some have grading system, like you are 1-star social enterprise, you have 2-star, 3-star. So we've seen the adaptation of these international experience to local practice. And over time, it's kind of a dynamic of trust and scale. But it's a tinkering. So there are like risk of fraudulent. So some just because it's governmental, they have startup grants. So even if you are certified, they give you some startup money with no string attached. Some will use the name to get that money, but so it's also still a tinkering process. How flexible, how restrictive the standard should be, and how to maintain social trust, but also the confidence of the investors.
Thank you. So, as you can imagine, it's been a tremendous learning opportunity working on this project for everyone, I hope, who has been involved. We shared, drafts. We had a kind of common site where everyone could learn about each other's work. And I'm excited to report that many of our reporters, including our panelists here, have seen this work as stimulating of future research as well. And so I want to give them an opportunity to just briefly mention where they're going next, and then we'll open up for questions. So Alvaro, could you start us off?
Yes, many thanks again. Just to pick up where I left it, because we've been hearing comments from so many jurisdictions. Just to recall that Colombia, which was the countries that I focused on, adopted the legal certification system, and that my diagnosis was that overall it was a positive step forward. It generated awareness among consumers and investors, but it felt a little bit short for lack of government support. The highest number of new entities, legal certified entities, was in 2022. Since then, we haven't seen that many new entities adopting the legal certification system, and a concerning trend is that many registered and certified entities have been voluntarily surrendering their certification. So one thing that we might want to look at closer, and something that I'm certainly conducting research now, is what are the reasons for companies to remove their certification. Colombia was the first country in Latin America to adopt a legal certification system, but it was followed by other countries, excuse me, that experienced similar realities than the one that I described before, and good growth opportunities and unmet social objectives. So there are reasons for removing the certification. What I have gathered is that it's cumbersome, especially for new entry entrepreneurs, to comply with all these 5 dimensions that I mentioned at the beginning. The law was rather strict. I acknowledge that the aim was to have something comparable, adopting a disclosure report, for example, that complies with international standards. Is better for the regulator to assess in which areas are social enterprises making progress, but it has proven cumbersome, especially for new entry, for new entrepreneurs. I think relatedly, there might be a phenomenon of greenwashing. There are many companies, around half of the entities that adopted the legal certification were established entities that, of course, have all the resources to comply this information, to report on time, and to make progress faster. But we don't know yet from the information that they have disclosed whether there's a level of greenwashing, there's skepticism from certain industry participants. And one last thing that I'd like to mention is that the Colombian law created a rule that enabled any stakeholder to require the superintendents of companies, which is the regulator that collects these reports and that is entitled to impose fines and control their behavior. Any stakeholder can require the decertification or the removal of the legal certification. I think it's an interesting innovation that in our report, we felt that it might have been too much, too harsh of a requirement, but I wonder whether this has indeed exercised some pressure in the way that these companies have been managed. But in a nutshell, I think for future research would be the reasons to remove the certification and whether the experience that we have accumulated over the past 4 years may indeed demonstrate that it might be better to introduce a new corporate entity, a new business entity, allowing the pursuit of mission and profit instead of simply a legal certification, which seems to have been short in its aims.
Thank you. So Giedra and Meng, do you have new research related to this you want to mention?
Yes, thank you, Dana. I have indeed an article which is coming up, which is inspired by this research and also by your research with Stephen Dean on for-profit philanthropy. And basically, I'm looking into to what extent can so I'm looking from tax perspective, right? Can a charitable entity conduct business activities and be still tax exempt and fall under charitable regime? Which is, to be honest, in the canton of Geneva, where I live, it's very generous. You can have up to 50% of your revenue coming from business activities and still be completely tax exempt under charity regime. But some people say that even this is not enough. We should have more. And yeah, that's it. So I'm writing about that. I think 50% is really enough, to be honest. But there is another point, which also we discussed with Dana, more general. Like, you know, we are having currently this huge global corporate tax reform, which tackles very big corporations who have a turnover over 650 million euros. And basically, we are creating laws tax laws that are different for big companies and for small, which is very logical because it always seemed to me completely illogical that we apply the same corporate taxation to patisserie on the corner and to Procter & Gamble. You know, it's not the same thing. So it's happening in corporate tax law in general, and I was thinking to what extent we could apply this to philanthropy, big versus small, because I don't have, with my deduction of $50 per year or $100 per year, I don't have the same tax planning and problems or ideas as big philanthropists. That's another point I would like to tackle. Thank you.
Great. Meng, do you want to mention anything? And
Yeah.
please do come down to the microphones if you have questions. We have time for some questions too.
Yeah, so Ghidra is working on taxing the big companies. So I'm going to work on helping small business. So I'm now more of a quantitative social scientist. So I'm planning to do some policy analysis for tax incentives for small business and a for-profit to be like more social oriented. We did a project based in the UK data to see nursing homes. If you are a CIC, the legal social enterprise form, and nonprofit, they perform much better than the for-profit in their quality readings. So I'm hoping to do some cost-benefit analysis if there are like local policy initiatives to have incentive incentives for smaller business or lower interest business to see like hopefully find some comparative groups. Maybe the federalism, some states have this policy, some states don't, to compare the impact, the causal effects of such policy intervention in helping the for-profit world to shift to like the paradigm of neoliberalism on all center around working for shareholders' return, but also have concerns for the communities, the employees, and other stakeholders.
Excellent. Looks like we have a question.
In the scope of what you looked at, did you find could you give us any highlights of any unusual restrictions or other real sort of oddballs? I sat in the back and I was thinking, well, where you've got a B Corp or some other sort of social benefit entity, are there restrictions on your ability, sort of like nonprofits here, to lobby or to do other like donating to political campaigns and like, or things like that, or anything quirky that's another restriction that we maybe have in the U.S.?
Sure. I mean, I don't know if I would say they're quirky. I think it really has to do with the baseline, right, of what the expectation is. But things that surprised me, I can certainly mention a couple. And I don't know, Ghidra is familiar with more of the reports, but if any of my colleagues have comments as well. One thing I noticed in a few of the certification regimes was a requirement to not be involved with the government. Right. And to have the government be, not a funder, not have control, not be related. And then in other certification examples and even a few of the forms, a requirement to have government as kind of a partner. Right. So again, it really depends on what the economy looks like. Right. And the level of trust or mistrust or expectation in terms of what government interaction would be. Another thing that struck me as surprising, because it's not something that we have seen on the scene as much in the U.S., is something that Alvaro mentioned, which is links to the procurement systems. Very common to see that as an initial place where governments can experiment with incentives is in their procurement systems. And even when the certification is being developed by a private entity. So we have an example in our New Zealand report where a totally private certification can certify entities for preferencing in the public procurement system. And so those are just a couple of examples. I don't know if anyone else, I can't see Alvaro.
Yeah, a very quick sharing of the case of China on the regulation of nonprofits. So in terms to be like have business income, it's really hard for them to assure their regulators they are not breaching their nonprofit nature. And there's no concept of program related investment in China. So the regulators don't like PMR even though they want to do, because it's like shrinking of the charitable assets. So they are really doing it in a turnaround way. And we have also newly the charitable trust system. So they will set a charitable trust where there's a program in investment funds and packaging it in other ways, because we still don't have this concept to avoid any issues.
There's also really wide variety in terms of the expectation and permission to engage in trading or business activities by nonprofits. That's one of those really key baselines that we notice, going from everything from you can have absolutely no commercial activity to huge flexibility, as Gedra mentioned.
One question I wanted to ask is, in terms of the benefits, are they designed to be limited to the country? So is your benefit in Denmark supposed to be only in Denmark, or are you allowed to be global? That's one of the things that we in the pro bono world have kind of faced.
So all of our reports all of our country reports really focus just on what's happening in the jurisdiction, but we do have a report on the EU that is a special report that kind of transcends jurisdictional boundaries. And that's where we saw the most experimentation with kind of portability and a desire on the part of the EU to develop some kind of EU-wide approach to this issue, you would all know about it if it were in effect yet, but it seems like that's something that's being worked on as a possibility, although the experience of the European Foundation debacle and other things at the EU level falling apart and trying to coordinate across all those jurisdictions definitely, means any optimism around an EU level response to this should be cautious optimism, I would say.
So perhaps I could just add, because there was a new development, very, very recent. There is a now proposal for European cross-border association, right, which was put forward, which is a single model, which would be recognized in the entire European Union. So we'll see how it goes. It's not the first time they try, but this time there is more, this time there is more lobbying. And just on the EU point, it's quite interesting, to be honest, because the EU is the only bloc in the world which liberalized philanthropic capital movement, at least in theory, between countries. So if as a donor I give to Sweden, and I want to deduct in Lithuania, Switzerland is not a part of the European Union, I can deduct. Now there are technical problems proving to your tax administration that, so there are administrative problems, but to be honest, that's the only place in the world where it's legal, and they are working to make it more and more smooth, which I find interesting.
So stay tuned. There'll be a lot more exciting work in the space. And that includes work that my co-author Stephen Dean and I are doing on, we're building a grant application to empirically test some of this idea of the spectrum in a variety of jurisdictions around the world. And we're going to need partners on the ground. So definitely watch this space. Thank you so much for your attention.
Thank you.